This presentation will focus on the Manual of Patent Examining Procedure and its use by examiners and patent professionals. In particular, the discussion will address what the MPEP is, why it's important, its contents and structure, and how to access and navigate the MPEP. The MPEP is designed as a reference text to answer questions that arise during patent examination and prosecution. It documents the USPTO's practice and procedures. It is a practical working document that fills in the gaps of how the applicable laws and regulations are actually implemented during examination and prosecution. Note that the MPEP is an externally published document, so its audience includes applicants and attorneys in addition to patent examiners. Much of the manual will become second nature as you gain experience with examining, but it will always serve as a reminder of how or why certain aspects of such material are treated. Conversely, much of the manual will never be second nature. It is a necessary reference to efficiently provide answers to both common and uncommon issues and questions. Always remember that you are not expected to know everything, but you are expected to know how to find what you need, and the MPEP is your best ally in that regard. Note that while the MPEP is the authoritative source for current USPTO procedures, it does not have the force of law or rules. It does, however, have the administrative force that any systematic collection of practices and procedures has. It evidences how the agency expects patent examination and prosecution to flow. The MPEP provides analysis to help you interpret the law and rules and guidance as to how laws and rules are applied during patent prosecution. We'll now discuss what types of information can be found in the MPEP and how it is structured. The MPEP has a regular pattern to the information in each section. By knowing the pattern, you can scan the material, get up to speed on a topic you are researching, and quickly find the section to immerse yourself in more fully. When applicable, each MPEP section begins with the laws, rules, and judicial opinions that apply to a specific topic, then goes on to discuss how the USPTO follows those laws, rules, and judicial opinions, how to analyze the more complex situations that arise, and how to communicate your findings. The recitation of policy and procedure, which is the bulk of the MPEP, elaborates on USPTO practices and keeping with the laws, rules, and judicial opinions. Guidelines set forth comprehensive analysis of individual topics, and form paragraphs provide approved templates for conveying information in office actions. Later in this presentation, we'll discuss and look at examples of each type of information in more detail. This slide shows the high-level organization of MPEP chapters and appendices. Chapters 100 through 600 deal primarily with the requirements of the application itself and the obligations of the parties supplying the application. Chapters 700 through 1400 delves into the examination process in detail. Chapters 1500 through 2000 cover specialized areas such as Patent Cooperation Treaty or PCT and will be used less frequently by most examiners. Chapters 2100 through 2800 are dominated by large, almost treatise-like chapters on patent law, re-examination practice, interferences, and special issues arising in biotechnology applications. Finally, the appendices provide references that cut across chapter topics. Chapter 2100, Patentability, and Chapter 700, Examination, are the most chapters used by examiners. In many ways, all of the other chapters are supportive footnotes to these two chapters. Having said that, Chapter 2100 is not totally comprehensive as to patent law, and we will outline which chapters you will have to look to for patent laws that are not in Chapter 2100. Let's first look at the chapters relating to the application process. Chapter 100 deals with secrecy and access to applications. Specifically, this chapter touches on secrecy orders, foreign licensing, and inspection rights. Chapter 200 deals with the various types of applications and will be discussed further on the next slide. Chapter 300 deals with the assignee. The assignee is the party who holds the rights to the invention claimed in an application or patent. Chapter 400 deals with parties representing the inventor. This generally refers to attorneys and registered agents, but may also refer to executors and administrators. Issues regarding powers of attorney and who may or may not act in representative capacity in differing circumstances are addressed in this chapter. Chapter 500 deals with the clerical aspects of receiving application papers. Of note are sections on payment of fees, certificate of mailing or transmission practice, and improper routing of papers. Chapter 600 is the most relevant of these chapters with respect to examiners and will be discussed further after Chapter 200. Types of Applications is a separate module in the Patent Training Academy, and its contents come from MPEP Chapter 200. This chapter helps us determine the criteria and implications of different application types, such as national versus international, provisional versus non-provisional, and divisional versus continuation in part. Further, this chapter provides information on filing dates and how applicants can claim the benefit or previously filed foreign or domestic applications. The chapter also defines terms relating to the status of an application such as new, rejected, amended, allowed, and abandoned. Chapter 600 deals with the formal requirements of an application. Listed here are some of its sections that are most relevant to patent examining. Section 601 specifically identifies the contents of an application. Sections 602 to 604 should be consulted when there are issues regarding the oath or declaration. Section 608 relates to the contents of the disclosure, and finally, Section 609 extensively treats information disclosure statements wherein applicants disclose any known references pertinent to the claimed invention. The next section of the MPEP falls under the broad category of examination and details much of the examination and prosecution process. Chapters 700, 800, 900, 1200, and 1300 are most applicable to the work of the examiner and will be discussed in subsequent slides. Chapter 1000. Chapter 1000 discusses who has authority to decide various types of petitions filed by applicants and also outlines the authority of examiners with full and partial signatory authority, those at the GS13 to 15 grade levels. Chapter 1100 outlines the publication of a special type of document referred to as a Statutory Invention Registration, or SIR, as well as the process for pre-grant publication of patent applications. SIR documents are no longer in use after March 16, 2013. Chapters 1200 and 1300 are fairly complex and present treatises on the procedures for appeal and allowance, two avenues by which the application process is concluded. Finally, Chapter 1400 focuses on post-patent correction measures. The chapter includes information on practice and procedure with respect to reissue applications and certificates of correction. Chapter 700 can be called the examiner's best friend. It specifically addresses the examination process, including actions examiners take during prosecution of an application, such as rejecting claims, communicating rejections to applicants in the form of office actions, and dealing with replies from applicants, including treatment of amendments and evidence filed by applicants. Of particular note is Section 706, which covers rejections. Examiners primarily give opinions on patentability by allowing, objecting to, or rejecting an application's claims. The law requires the examiner to lay out the reasoning for each rejection. Section 706 frames the manner in which each type of rejection is to be made. Note that there are different subsections for prior art rejections and those based on something other than prior art. There is also a subsection devoted to practice and procedure when making a final rejection. If an issue arises regarding rejection of a claim, odds are one of these sections is relevant. Chapter 800 discusses restriction practice, which is a means for curtailing examination to a single invention in an application. The chapter also discusses double patenting practice, which refers to the treatment of identical claims or claims which are not patentably distinct from one another, which appear in multiple applications by the same inventor or assignee. Both of these topics will be described in further detail in later presentations. Chapter 900 provides information on how and where to search for the invention you are examining. It includes a high-level discussion of what constitutes prior art, as well as a high-level look at search tools and the patent classification system. Chapter 1200 covers any issue involving the appeal process. It provides guidance on practice and procedure, including appeal briefs, examiner's answer, and actions the examiner should take after the Patent Trial and Appeal Board has rendered a decision. It also includes checklists that outline the content requirements for appeal briefs and examiner answers. Chapter 1300 deals with the practices and procedures when an application is ready for allowance. From an examiner's perspective, the sections on examiner's amendments and reasons for allowance are most critical. Examiner's amendments refer to the practice of having an examiner make amendments or changes to a pending application, usually with the authorization of the applicant, in order to place the application in condition for allowance. Reasons for allowance indicate why the claims of the application being examined are patentably distinguishable from the relevant prior art. Chapters 1500 through 2000 are generally considered to be specialized areas of the MPEP. Unless you are a design or plant examiner, Chapter 1800 on applications filed under that Patent Cooperation Treaty, or PCT, will be the one you use most frequently among those listed here. When your issues are more substantive than procedural, you should gravitate towards Chapter 2100 through 2700. Of particular importance, Chapter 2100 is the USPTO's treaties on patent law and will be discussed in further detail on the next few slides. Chapters 2200 and 2600 focus on reexamination practice and procedure, with Chapter 2200 focusing on ex parte reexamination and Chapter 2600 focusing on inter partes reexamination. Chapter 2300 covers interference practice, which involves proceedings for solving priority issues between multiple patent applications from different inventors. Note that interference proceedings are only available to applications filed prior to March 16, 2013. The 3 remaining chapters are devoted to maintenance fees, biotechnology issues, and patent term extensions. Chapter 2100 is the USPTO's textbook on patent law. It contains policies and guidelines with respect to the determination of patentability under 35 U.S.C. Sections 101, 102, 103, and 112, except for pre-AIA 102E dates, which can be found in Section 706. Chapter 2100 also includes relevant portions from court decisions, which form the basis for interpretation of statutes and regulations. Note the interplay between Chapters 700 and 2100. 2100 gives the criteria and analysis for consideration, while 700 demonstrates how to communicate it. This slide shows the major breakouts in Chapter 2100 to help you get familiar with where to find significant discussion of patentability related to 35 U.S.C. Sections 101, 102, 103, and 112, as well as claim construction, inherency, and prior art. MPEP appendices can be used to quickly find specific references, particularly patent laws in Appendix L and patent rules in Appendix R. The Alphabetic Subject Matter Index provides an alternative to the table of contents if you cannot remember which chapter covers a particular topic. Now that you understand the basic structure of the MPEP and the types of information found there, the rest of this presentation will focus on basic navigation to find various types of information in the MPEP. MPEP navigation techniques will be covered in much more detail during a separate hands-on eMPEP training. The MPEP is available internally for USPTO employees on the USPTO intranet, as well as externally to the public. The browser-based electronic version, referred to as the eMPEP, provides numerous features to make it easier for you to navigate, search, and even add personalized settings and notes based on how you use the MPEP. For easy access to the latest version of USPTO practices and procedures, The eMPEP is included in the Patent Examiner's Toolkit on the Universal Laptop. Please open the eMPEP in a separate window at this time so that you can practice locating what's being shown in the next few slides. Note that the menu at left when you open up the eMPEP is the table of contents. Clicking on the triangle next to the chapter number expands that chapter so you can see a list of sections, and if there are subsections, there will also be a clickable triangle to reveal links to those in the table of contents. Thus, if you know which specific section or subsection to go to, you can use the table of contents to get there quickly. Inside a chapter, the contents can be highly intricate and detailed, but the hierarchical organization of sections and subsections can help you avoid getting lost in lengthy chapters. In addition to the table of contents, the eMPEP also features a subject matter index found at the bottom of the table of contents. Alphabetical headings are subdivided into subheadings and give keyword type access to frequently consulted sections. Section numbers are then hyperlinked to take you directly to where that topic is covered. Within the chapters and sections, hyperlinks also provide quick access to cited laws, rules, and court decisions. These hyperlinks can be used to navigate to the full text of the corresponding reference. References to cases frequently suggest related issues that arose in that case. You can also search for keywords or phrases using the search menu at the top of the page. Before we look at an example of a statute in the MPEP, let's discuss some background information on them. Statutes are acts passed by Congress that lay out rights, duties, and obligations. Essentially, no administrative agency can do anything other than what is legislated. Some laws are permissive, while others are mandatory. When statutes use verb forms including must, will, shall, or similar forms, the action is mandatory. It must be done. Alternatively, the use of verbs like may, should, can, and could are permissive and indicate what one is allowed but not required to do. The laws give the USPTO its authority, including authority to create rules and to waive those rules. The laws also spell out the USPTO's obligations and its powers and limitations in meeting those obligations. Therefore, any MPEP section that is predicated on a law will spell out that law up front and refer to the pertinent portions in the discussion of related policies and procedures. To see an example of how statutes are included in the MPEP, go to Section 601, Content of Provisional and Non-Provisional Applications, using the table of contents. Here, the statute is included because it is the legal source for required contents of patent applications. This statute also includes hyperlinks to related statutes 35 U.S.C. 112, 113, and 115. Remember that the entire collection of statutes can also be found in Appendix L, Patent Laws. As previously stated, patent laws specifically authorize the USPTO to make regulations, also referred to as rules to be followed during patent prosecution. These are codified in the Code of Federal Regulations, or CFR. The rules establish the obligations of each of the parties, such as the requirements for each filing and the timeframes for response. Thus, the rules allow the USPTO to mandate consistent and efficient practice in its operations. Scrolling down within Section 601, you can see that below the statute is the recitation of the applicable rule, 37 CFR 1.51, which discusses the required contents for a complete application. This rule also includes references to other rules for clarification. Remember that the entire collection of rules can also be found in Appendix R, Patent Rules. Policies and procedures are the nuts and bolts of the MPEP. They take the high-level laws and rules and set forth the policies of the USPTO, detailing the interpretation of how USPTO staff are to actually perform their functions. The detailed procedures fill in the blanks as to the purpose of various functions, how staff are to prepare for and execute those functions, and how to follow up. These policies and procedures are the actual administrative instructions on how to conduct USPTO operations. Whenever there is a question or issue regarding how such operations are to be conducted, the MPEP is the definitive source. In this screenshot, we have the result of clicking on 606 in the table of contents on the left, which describes requirements for the title of the invention. Rule 1.72 is recited, followed by policies and procedures for titles and what the examiner is to do if the title is not descriptive. Read to learn about some words that may need to be deleted if included in the title of an invention. By reading this section, we learn that words such as new, improved, and improvement should not be included at the beginning of the title of an invention. Similarly, a, and the should not be the first words of a title. In addition to policies and procedures, MPEP sections sometimes includes guidelines. Guidelines are fairly comprehensive discussions of certain regularly recurring issues, including the instructions from the USPTO to its staff on how to analyze and treat those issues. Guidelines may contain several citations of laws, regulations, and court cases. Guidelines are referred to as such because they treat issues that require interpretation, analysis, and judgment. The guidelines are tools to aid the staff in treating the issue, but cannot themselves provide an explicit manner of treatment because the appropriate treatment is often fact-specific. It is important to understand that guidelines provide suggested manners of treatment under differing circumstances, and these treatments are the USPTO's official policy in those situations. To see an example of guidelines in the MPEP, go to Section 2141, which provides examination guidelines for determining obviousness under 35 U.S.C. 103, just below the statute. The highlighted text states, "These guidelines do not constitute substantive rulemaking and hence do not have the force and effect of law. They have been developed as a matter of internal office management and are not intended to create any right or benefit, substantive or procedural, enforceable by any party against the office." The USPTO sets forth office policy with respect to interpretation of judicial decisions in the MPEP. When presented with case law, the MPEP should be consulted to determine the current stance of the USPTO with respect to the stated proposition. However, it's important to remember the MPEP only provides a summary. Thus, it may be necessary to consult the judicial decisions themselves for further clarification of a topic. This is covered in a separate presentation on how to read and understand case law. Here's an example of a citation to case law found in MPEP Section 2141, just below the examination guidelines for determining obviousness. The case discussed is KSR International versus Teleflex Incorporated, commonly referred to as KSR. Appendix 2 provides an alphabetical listing of all cases cited in the MPEP, which you could use to find where else the MPEP cites or explains KSR. Finally, there are a number of form paragraphs in the MPEP. These are templates to be incorporated in written communications, specifically office actions. Each form paragraph corresponds to a specific response to a specific issue. The MPEP indicates when examiners should utilize specific form paragraphs. Form paragraphs serve several purposes. They save the examiner time by providing a pre-written template that addresses specific issues. They provide consistency in treatment so that recipients are not surprised by the contents of communications as they conform to the MPEP, and recipients can rely on the basic message conveyed by the form paragraph without ambiguity. And they can serve as a checklist to ensure the examiner includes all necessary statements appropriate in each situation. Form paragraphs are shaded when included within an MPEP section, as shown in this example from Section 608.01J. It follows a recitation of the corresponding rule and is specifically for the examiner to use to communicate to the applicant that their claims are not numbered properly. You can also find all the form paragraphs using the form paragraph book found at the bottom of the eMPEP table of contents, directly below the MPEP subject matter index. But form paragraphs in the MPEP are simply reference material. Examiners use the Office Action Correspondence System, or OACS, to assemble the form paragraphs needed in each office action, depending on the issues present in each application. In addition to the interactive browser-based eMPEP, PDF, and HTML versions of the MPEP may be accessed from any computer via the USPTO's public internet website. You should now be more familiar with what the MPEP is and why it's important, the contents and structure of the MPEP, and how to access and navigate the MPEP.
The main topics for this training include becoming familiar with preparing for the proficiency exam, the basic contents of the MPEP 600 for future patent examining functions, and becoming more efficient in looking up an answer to each question you may have. More specific to this module, we will cover the parts, form, and contents of a patent application. Listed here are some of the more commonly used sections. The requirements for obtaining a filing date for a provisional and non-provisional application differ as outlined in MPEP 601.01a and b and prescribed by 37 CFR 1.53b for non-provisional applications and 37 CFR 1.53c for provisional applications. Although both types of applications require the filing of a specification in compliance with 35 U.S.C. 112a, as well as drawings if necessary, the non-provisional application additionally requires the filing of at least one claim to obtain a filing date if the application was filed before December 18, 2013. Except for design applications, the filing date for applications filed under 35 U.S.C. 111 on or after December 18, 2013 is the date on which a specification with or without claims is received in the office. However, at least one claim is still required in order for a non-provisional application filed on or after December 18, 2013 to be a complete application. MPEP sections 601.01d, E, F, and G all deal with procedures and requirements when certain items are omitted from the application at time of filing. What is an application datasheet or ADS? And must an applicant file an ADS? An application datasheet is a sheet or sheets containing bibliographic data for the application. The application datasheet may be voluntarily submitted for applications filed prior to September 16, 2012, but is required in various situations for applications filed on or after September 16, 2012. Situations where an ADS must be filed for applications filed on or after September 16, 2012 are when 1. Submission of the inventor's oath or declaration is to be postponed. 2. Each inventor's oath or declaration identifies only the inventor or person executing that particular oath or declaration and not all of the inventors. 3. There is a claim for domestic benefit, 37 CFR 1.78, or foreign priority claim, 37 CFR 1.55, except foreign priority for national stage applications, or 4. There is an identification of applicants other than the inventors under 37 CFR 1.46, except for national stage applications, where the applicant is the person identified in the international stage. The application data sheet must be titled Application Data Sheet and must contain all of the section headings listed in 37 CFR 1.76b. The requirements of 37 CFR 1.76b differ slightly depending whether the application was filed prior to September 16, 2012 or thereafter. For applications filed prior to September 16, 2012, can the applicant file a supplemental ADS to correct or update the information? Yes, applicant is allowed to correct or update the information in the application data sheet or sheets by filing a supplemental ADS prior to payment of the issue fee for applications filed before September 16, 2012. However, for applications filed on or after September 16, 2012, the newly submitted ADS is no longer considered a supplemental ADS. Rather, it is referred to as a corrected or updated ADS. For applications filed prior to September 16, 2012, when there is an inconsistency between the application data sheet and other documents, such as the oath or declaration, 37 CFR 1.76d 1 through 4 establish the criteria for which information governs. D1. The latest submitted information except as provided by paragraph D3 on the next slide. D2. The information in the ADS, when the inconsistent information is supplied at the same time by an amendment, a designation of a correspondence address, or an oath or declaration, except as provided by paragraph D3 on the next slide. D3. The oath or declaration governs inconsistencies with an ADS in the naming of inventors and their citizenship. D4. The office will capture bibliographic information from the ADS initially. Captured bibliographic information derived from an application data sheet containing errors may be corrected if applicant submits a request therefor and a supplemental application data sheet. In the case of applications filed on or after September 16, 2012, the information is governed according to the new 37 CFR 1.76d 1 through 3 in the following manner. D1. The most recent submission will govern with respect to inconsistencies as between the information provided in an application data sheet, a designation of a correspondence address, or by the inventor's oath or declaration, except that 1. The most recent application data sheet will govern with respect to foreign priority 1.55 or domestic benefit 1.78 claims, and 2. The naming of the inventorship is governed by 1.41 and changes to inventorship or names of the inventors is governed by 1.48. D2. The information in the application datasheet will govern when the inconsistent information is supplied at the same time by a designation of correspondence address or the inventor's oath or declaration. D3. The office will capture bibliographic information from the application datasheet. The office will generally not review the inventor's oath or declaration to determine if the bibliographic information contained therein is consistent with the bibliographic information provided in an application datasheet. Incorrect bibliographic information contained in an application datasheet may be corrected as provided in 37 CFR 1.76c. The abstract is a part of a written patent application. Abstract is a short summary of the invention written in one paragraph to quickly determine the nature and gist of the disclosure. 37 CFR 1.72b provides that the abstract commence on a separate sheet, preferably does not exceed 150 words in length, contains language which is clear and concise, should not refer to purported merits or speculative applications of the invention, and should not compare the invention with the prior art. The abstract is considered part of the specification and can be taken into consideration for the purpose of determining compliance with 35 U.S.C. 112, even though it is on a separate sheet following the claims in the application. Any new abstract or amendments to the abstract submitted after the filing of the application should be reviewed for new matter. If an application is otherwise in condition for allowance except that the abstract does not comply with the guidelines, the examiner generally should make any necessary revisions by a formal examiner's amendment after obtaining applicant's authorization, rather than issuing an ex parte quail action requiring applicant to make the necessary revisions. MPEP 608.01L addresses disclosure as it pertains to claims present on the application filing date, and states that in cases where subject matter not shown in the drawing or described in the description is found in the claims present on the application filing date, the claim should not be rejected or objected to, but rather it is the drawing and description that are defective, and not the claim. Make sure you fully understand the posed question before selecting an answer. In this case, the question indicates that the claim includes subject matter that has a sufficient disclosure and therefore meets the written description requirement of 35 U.S.C. 112a. However, a further analysis of the question reveals that the question asks which of the following is not, so the answer that is false would be the correct choice. It always helps to review all the answers before settling on your final choice. In this case, answers B and C appear to be opposite answers, in which case both cannot be true. The specification, non-provisional application, should conclude with at least one claim on a separate physical sheet or electronic page, must meet 35 U.S.C. 112b. Original numbering of claims must be preserved through prosecution. When claims are canceled, the remaining claims must not be renumbered. Reference characters should be enclosed within parentheses. Each claim begins with a capital letter and ends with a period, as in single sentence. Various types of illustrations are permitted in the specification and the claims. While both the specification and claims are allowed to contain chemical formulas, mathematical equations, and tables, the rules for what types of tables are permitted in each section differ. When an application contains graphs, drawings, or flowcharts in the specification, the examiner should object to such descriptive illustrations and request drawings in accordance with 37 CFR 1.81. Hyperlinks and other forms of browser executable codes are not permitted in the specification since, when the patent document is placed on a USPTO web page, the existence of such code may result in a user being transferred to another web page identified by the URL, if it exists, which could be a commercial website. USPTO policy does not permit the USPTO to link to any commercial sites, since the USPTO exercises no control over the organization, views, or accuracy of the information contained on these outside sites. If hyperlinks and/or other forms of browser executable code are embedded in the text of the patent application, examiners should object to the specification and indicate to applicants that the embedded hyperlinks and/or other forms of browser executable code are impermissible and that references to websites should be limited to the top-level domain name without any prefix such as http:// or other browser executable code. This requirement does not apply to electronic documents listed on Forms PTO 892 and PTO SB 08, where the electronic document is identified by reference to a URL. MPEP 608.01n addresses various criteria for dependent claims, provides numerous examples, and addresses how such claims should be handled. Some of the more commonly seen reasons for improper dependent claims occur when multiple dependent claims are present in an application. Multiple dependent claims should refer to other claims in the alternative only and cannot depend on any other multiple dependent claim. A dependent claim refers to an earlier claim, incorporates by reference all of the limitations of that claim, and then specifies a further limitation. Each dependent claim is, by law, more narrow than the independent claim upon which it depends. 37 CFR 1.75 stipulates that a dependent claim may be presented in dependent form, referring back to and further limiting another claim or claims in the same application. At the same time, 35 U.S.C. 112d requires a dependent claim to further limit the subject matter in a previous claim. Now let's consider the following with respect to question 7. Is Claim 9 a proper independent claim? Is Claim 10 a proper dependent claim to Claim 9? Is Claim 11 a proper dependent claim to Claim 10? Step 1. Yes, Claim 9 is an original claim which is part of the original disclosure. Thus, answer options C and D are incorrect. Step 2. Yes, Claim 10 further limits the subject matter of Claim 9 by limiting the clock speed of the microprocessor. Thus, answer option B is incorrect. Step 3. No, Claim 11 does not further limit the scope of Claim 10 since it redefines the minimum memory size, greater than half a gigabyte, instead of further limiting the memory size of Claim 9, at least 1 gigabyte. The phrase "incorporated by reference" is found quite commonly in patent specifications, where it is used to supplement the disclosure by importing various portions of the reference document. MPEP 608.01p subsection 1 and 37 CFR 1.57c through h set forth the procedures and requirements for express incorporation by reference statements. An incorporation by reference must be set forth in the specification and must 1. Express a clear intent to incorporate by reference by using the root words incorporate and reference, for example, incorporate by reference. And 2. Clearly identify the reference patent, application, or publication. Exceptions to the requirements for express incorporation by reference statements are provided in 37 CFR 1.57a and b. Applicants are allowed to incorporate both essential and non-essential material in order to provide an enabling disclosure, describe the claimed invention, and/or to illustrate the state of the art. Although essential and non-essential material may be incorporated by reference to U.S. patents and U.S. patent application publications, non-essential material may also be incorporated by reference to foreign patents, non-patent literature, and prior or concurrently filed, commonly owned U.S. applications. Hyperlinks or other forms of browser executable code are not allowed. The phrase "incorporated by reference" is found quite commonly in patent specifications, where it is used to supplement the disclosure by importing various portions of the reference document. MPEP 608.01p subsection 1 and 37 CFR 1.57c through h set forth the procedures and requirements for express incorporation by reference statements. An incorporation by reference must be set forth in the specification and must 1. Express a clear intent to incorporate by reference by using the root words incorporate and reference, for example, incorporate by reference. And 2. Clearly identify the reference patent, application, or publication. Exceptions to the requirements for express incorporation by reference statements are provided in 37 CFR 1.57a and b. Applicants are allowed to incorporate both essential and non-essential material in order to provide an enabling disclosure, describe the claimed invention, and/or to illustrate the state of the art. Although essential and non-essential material may be incorporated by reference to U.S. patents and U.S. patent application publications, non-essential material may also be incorporated by reference to foreign patents, non-patent literature, and prior or concurrently filed, commonly owned U.S. applications. Hyperlinks or other forms of browser executable code are not allowed. An information disclosure statement, often abbreviated as IDS, refers to a submission of relevant information to the USPTO by an applicant for a patent during the patent prosecution process. There is a duty on all patent applicants to disclose information that is material to the patentability of the claimed invention. The timing requirements of an IDS are defined in 37 CFR 1.97, also found in the MPEP, and include when an IDS may be filed and whether a 37 CFR 1.97E statement and/or fee is needed in order for the information in the IDS to be considered by the examiner. If an IDS is filed during any of the following time periods, the examiner must consider the IDS provided that the IDS also complies with the content requirements of 37 CFR 1.98. 1A for national applications, not including CPAs, within 3 months of filing or before first office action on the merits, whichever is later. 1B for national stage applications, within 3 months of entry into national stage or before the first office action on the merits, whichever is later. 1C for RCEs and CPAs, before the first office action on the merits. Two, if an IDS is filed after the period in 1, but before final action, notice of allowance, or quail action, a statement under 1.97E or fee set forth in 1.17P is required. 3. If an IDS is filed after the period in 2 and before or with payment of issue fee, a statement under 1.97E and fee set forth in 1.17P is required. 4. If an IDS is filed after payment of issue fee, the IDS will not be considered. The information submitted in an IDS typically includes a list of issued patents, published patent applications, U.S. applications, scientific journal articles, books, magazine articles, or any other published material that is relevant to the invention disclosed in the applicant's own patent application. Prior art or other information on an IDS is typically broken up into the following categories: U.S. patents, U.S. patent application publications, foreign patent documents, and non-patent literature, or NPL, documents. The content requirements of an IDS are defined in 37 CFR 1.98, which can be found in MPEP 609. The IDS must also include a legible copy of A. Each foreign patent document, B. Each publication or that portion which caused it to be listed other than U.S. patents and U.S. patent application publications, unless required by the office, C. For each cited pending unpublished U.S. application, the application specification, including the claims and any drawings of the application, or that portion of the application which caused it to be listed, including any claims directed to that portion, unless the cited pending U.S. application is stored in the image file wrapper, or IFW, system. See 37 CFR 1.98A2. The IDS must further include a concise explanation of the relevance for non-English information. See 37 CFR 1.98A3. A statement under 37 CFR 1.97E must state either 1. That each item of information contained in the information disclosure statement was first cited in any communication from a foreign patent office in a counterpart foreign application not more than 3 months prior to the filing of the statement, or 2. That no item of information contained in the information disclosure statement was cited in a communication from a foreign patent office in a counterpart foreign application, and, to the knowledge of the person signing the statement after making reasonable inquiry, no item of information contained in the information disclosure statement was known to any individual designated in 37 CFR 1.56C more than 3 months prior to the filing of the statement. Before looking into the answer options, we should ask: 1. Can an applicant file an IDS after a notice of allowance but before payment of issue fee? Yes, it requires 1.97E statement and 1.17P fee. Can the applicant in this case make a statement under 37 CFR 1.97E? No. The inventor, or individual designated in 37 CFR 1.56C, was aware of the reference before February 11, 2002, more than 3 months prior to the filing of the IDS. You should now be more familiar with how to prepare for the proficiency exam and be more aware of the basic contents of MPEP Chapter 600. You have also learned some techniques for looking up answers in the MPEP. The objectives and goals of this CBT are to prepare the examiner for the proficiency exam, review the basic contents of these portions of the MPEP for future patent examining functions, and to improve proficiency of looking up content in the MPEP. More specifically, MPEP Chapters 800, Restriction and Double Patenting, 1200, Appeal, and 1300, Allowance and Issue, will be covered. Amendments or other replies can be filed any time after the final rejection, at the same time as filing an appeal brief or after filing of an appeal brief. The entry of the amendments or reply is at discretion of the examiner. Amendments and replies are usually entered if their effect is to remove issues from appeal and or adopt suggestions made by the examiner during the prosecution. Amendments, affidavits, or other evidence filed with or after a notice of appeal, but before the appeal brief, may be admitted with the discretion of the examiner if the amendments cancel claims, the amendments comply with any requirements of form expressly set forth in a previous office action, or 2. Present rejected claims in better form for consideration on appeal, or amend the specification or claims upon a showing of good and sufficient reasons why the amendment is necessary and was not earlier presented. The filing of an RCE after a notice of appeal will be treated as a withdrawal of the appeal, regardless of whether the RCE includes the appropriate fee or a submission. Upon withdrawal of an appeal, claims that are indicated as allowed in the application will be issued and the rejected claims will be abandoned. Objected to claims that are allowable except for dependency from rejected claims will be treated as if they were rejected and will be abandoned with the rejected claims. If an RCE request is made after the notice of appeal but before the decision by the board, the application will be treated in accordance with MPEP 1215.01. If all of the claims are rejected, the proceedings are considered terminated and the application is considered abandoned. Objected to claims that are allowable except for dependency from rejected claims will be treated as if they were rejected and will be abandoned with the rejected claims. If there is at least one allowable claim, the allowed claims or claim should be passed to issue. If there is at least one allowable claim, but formal matter are outstanding, applicant should be given a shortened statutory time period of 2 months or 60 days. whichever is longer, in which to correct the formation matters. Double patenting results when the right to exclude granted by a first patent is unjustly extended by the grant of a later issued patent or patents. Before considering making a double patenting rejection, two or more patents or application must have at least one common inventor, common applicant, and/or be either commonly assigned or owned, or non-commonly assigned or owned, or commonly assigned or owned and subject to a joint research agreement. Next, there are two types of double patenting rejections to consider. First is statutory double patenting, when the claimed subject matter is identical, for example, word for word identical. The second is non-statutory double patenting, when the claimed subject matter is not identical, but directed to variations that are either anticipated by or obvious over the double patenting reference claims. The non-statutory double patenting rejections are made in the format of a 102 rejection, when the subject matter is not identically worded but anticipated, or 103 type of rejection, when the differences would have been obvious. The double patenting rejection must clearly explain the anticipation or the rationale for obviousness. Although the double patenting reference itself need not qualify as prior art, any secondary reference or references used in an obviousness analysis must qualify as prior art under 35 U.S.C. 102. Another double patenting scenario is there is no issued patent, but a PG pub with claims that qualify as either statutory or non-statutory double patenting. The PG pub will not be used to make the double patenting rejection. Instead, the examiner will use the serial number of the parent application of the PG pub. The serial number is printed on the PG pub. The examiner should consult the application in PE2E DAV and make the provisional rejection over the most recently amended set of claims. If the most recently amended claims no longer qualify as a reference for a provisional double patenting rejection, then the rejection should not be made. After making the appropriate double patenting rejections, consider if the applied patent or PG pub also qualifies as prior art under 35 U.S.C. 102 or 103. A statutory type of double patenting rejection can be overcome by amending or canceling the conflicting claims or subject matter so they are not coextensive in scope. A terminal disclaimer will not overcome a statutory double patenting rejection. A non-statutory double patenting rejection can be overcome by filing a terminal disclaimer. Additionally, a non-statutory double patenting rejection can be overcome by amending or canceling the conflicting claims or subject matter so they are not coextensive in scope. A statutory double patenting rejection can be avoided by amending the conflicting claims so that they are not coextensive in scope. Where the conflicting claims are in one or more pending applications and a patent, a rejection based on statutory type double patenting can also be avoided by canceling the conflicting claims in all the pending applications. Where the conflicting claims are in two or more pending applications, a provisional rejection based on statutory type double patenting can also be avoided by canceling the conflicting claims in all but one of the pending applications. A terminal disclaimer is not effective in overcoming a statutory double patenting rejection. The most important things to remember about double patenting rejections are the following. Double patenting rejections are made by only comparing the claims and not any other part of the application or specification. Double patenting rejections are independent of the relative effective filing dates between applications' claims versus the patent or application's claims. Only non-statutory double patenting rejections can be overcome by a terminal disclaimer. Both non-statutory and statutory double patenting rejections can be overcome by amending the claims. If, on examination, the examiner finds the claims to an invention elected without traverse to be allowable and no non-elected invention is eligible for rejoinder, the letter should be attached to the notice of allowability and include cancellation of the non-elected claims, a statement that the prosecution is closed, and that a notice of allowance will be sent in due course. If the correction of formal matters in the above noted situation cannot be handled by a telephone call and thus requires action by the applicant, the correction should be handled under the ex parte quail practice. After a decision by the PTAB, the examiner's rejection and the examiner's answer are affirmed, affirmed in part, or reversed. If no claims are indicated by the PTAB as allowable, the proceedings in an application or ex parte re-examination proceeding are terminated as of the date of the expiration of the time for filing court action. The application is no longer considered pending. It is to be stamped abandoned and sent to abandoned files. In an ex parte re-examination proceeding, a re-examination certificate should be issued under 37 CFR 1.570. If in response to the PTAB decision claims stand allowed, the appellant is not required to file a reply. The examiner issues the application or ex parte re-examination certificate on the claims which stand allowed. If the PTAB affirms the examiner's rejection in whole or part, such that there are allowed claims and either rejected or objected to claims, the examiner must allow the allowed claims and cancel the rejected claims. For example, if the board affirms a rejection of Claim 1, Claim 2 was objected to prior to appeal as being allowable except for its dependency from Claim 1, and independent Claim 3 is allowed, the examiner should cancel Claims 1 and 2 and issue the application or ex parte re-examination certificate with Claim 3 only. The office will consider an information disclosure statement after a notice of allowance has been issued under the rules set forth by 37 CFR 1.97d. D. An information disclosure statement shall be considered by the office if filed by the applicant after the period specified in paragraph C of this section, provided that the information disclosure statement is filed on or before payment of the issue fee and is accompanied by 1. The statement specified in paragraph E of this section, and 2. The fee set forth in section 1.17p. The office will consider an information disclosure statement after a notice of allowance has been issued under the rules set forth by 37 CFR 1.97e, A statement under this section must state either 1. That each item of information contained in the information disclosure statement was first cited in any communication from a foreign patent office in a counterpart foreign application not more than 3 months prior to the filing of the information disclosure statement, or 2. That no item of information contained in the information disclosure statement was cited in a communication from a foreign patent office in a counterpart foreign application, and, to the knowledge of the person signing the certification after making reasonable inquiry, no item of information contained in the information disclosure statement was known to any individual designated in Section 1.56c more than 3 months prior to the filing of the information disclosure statement. The issue fee and any required publication fee are due 3 months from the date of the notice of allowance. An application can be withdrawn from issue at the initiation of the applicant. Prior to the payment of issue fee, if the applicant wishes to have an application withdrawn from issue, he or she must petition the director under 37 CFR 1.313a or file a request for continued examination, or RCE. A submission may be an information disclosure statement or an amendment. The RCE practice does not apply to utility or plant applications filed before June 8, 1995, and design applications. Prior to the payment of issue fee, if applicant has not paid the issue fee and wants to withdraw the application from issue in favor of filing an RCE, the applicant need not pay the issue fee to avoid abandonment of the application. Applicants are cautioned against filing an RCE prior to payment of the issue fee and subsequently paying the issue fee before the office acts on the RCE, because doing so may result in issuance of a patent without consideration of the RCE, if the RCE is not matched with the application before the application is processed into a patent. Furthermore, applicant may also file a continuing application on or before the day the issue fee is due and permit the parent application to become abandoned for failure to pay the issue fee. Once the applicant has paid the issue fee, withdrawal is permitted only for the reasons stated in 37 CFR 1.313c. The status of the application at the time the petition is filed is determinative of whether the petition is considered under 37 CFR 1.313a or 37 CFR 1.313c. Petitions under 37 CFR 1.313c to have an application withdrawn after payment of the issue fee should be directed to the Office of Petitions. After the payment of the issue fee of a utility or plant application, an applicant may wish to file a petition under 37 CFR 1.313c2 with an RCE or under 37 CFR 1.313c3 for the express abandonment of the application in favor of a continuing application under 37 CFR 1.53b, but not a CPA under 37 CFR 1.53d. Once the applicant has paid the issue fee, in addition to the specific reasons identified in 37 CFR 1.313c13, applicant should identify some specific and significant defects in the allowed application before the application will be withdrawn from issue. Such a petition under 37 CFR 1.313c2, along with a petition fee set forth in 37 CFR 1.17h, must include an RCE in compliance with 37 CFR 1.114. At any time during the period of enforceability of a patent, any person may cite to the office in writing prior art consisting of patents or printed publications which that person states to be pertinent and applicable to the patent and believes to have a bearing on the patentability of any claim of the patent. If the citation is made by the patent owner, the explanation of pertinence and applicability may include an explanation of how the claims differ from the prior art. Such citations shall be entered in the patent file except as set forth in 37 CFR 1.502 and 1.902. 37 CFR 1.56a states that the duty to disclose information exists until the application becomes abandoned. The duty to disclose information, however, does not end when an application becomes allowed, but extends until a patent is granted on that application. Amendment after allowance can be made under 37 CFR 1.132. However, no amendment may be made as a matter of right in an application after the mailing of the notice of allowance. Any amendment filed pursuant to this section must be filed before or with the payment of the issue fee and may be entered on the recommendation of the primary examiner, approved by the director, without withdrawing the application from issue. A proper response to a restriction requirement must include an election of one group and/or species. As shown by the first sentence of 37 CFR 1.143, the traverse to a requirement must be complete as required by 37 CFR 1.111b, which reads, in part, in order to be entitled to reconsideration or further examination, the applicant or patent owner must reply to the office action. The reply by the applicant or patent owner must be reduced to a writing which distinctly and specifically points out the supposed errors in the examiner's action and must reply to every ground of objection and rejection in the prior office action. The applicant's or patent owner's reply must appear throughout to be a bona fide attempt to advance the application or the re-examination proceeding to final action. Under this rule, the applicant is required to specifically point out the reasons on which he or she bases his or her conclusions that a requirement to restrict is in error. A mere broad allegation that the requirement is in error does not comply with the requirement of 37 CFR 1.111. Thus, the required provisional election becomes an election without traverse if accompanied by an incomplete traversal of the requirement for restriction. As noted in the second sentence of 37 CFR 1.143, applicant must elect even when the requirement is traversed. If applicant wants to preserve the right to petition a restriction requirement, they must elect with traverse. If applicant wants to preserve their right to petition a restriction requirement, they must elect a group and indicate the election is with traverse. Applicant should also distinctly and specifically point out supposed errors in the restriction requirement. If applicant fails to explicitly state the election is with or without traverse, the election should be treated as an election without traverse and be so indicated to the applicant in the office action. A restriction requirement is not appealable. The Patent Trial and Appeal Board does not consider restriction requirements. When writing an examiner's answer, a prior art reference that is cited to support the rejection in a minor capacity should be positively included in the statement of rejection. When writing an examiner's answer, there is no new ground of rejection when the basic thrust of the rejection remains the same, such that an appellant has been given a fair opportunity to react to the rejection. Where the statutory basis for the rejection remains the same, and the evidence relied upon in support of the rejection remains the same, a change in the discussion of, or rationale in support of, the rejection does not necessarily constitute a new ground of rejection. An applicant can appeal to the PTAB if any of the claims have been twice rejected by filing a notice of appeal accompanied by the appropriate fees within the time period provided for the response. MPEP 1204 states that an applicant for a patent dissatisfied with the primary examiner's decision in the second rejection of his or her claims may appeal to the board for review of the examiner's rejection by filing a notice of appeal and the required fee set forth in 37 CFR 41.20 B1 within the same time period provided under 37 CFR 1.134 and 1.136. A notice of appeal may be filed after any of the claims has been twice rejected, regardless of whether the claim or claims has or have been finally rejected. The limitation of twice rejected does not have to be related to a particular application. For example, if any claim was rejected in a parent application and the claim is again rejected in a continuing application, then applicant can choose to file an appeal in the continuing application, even if the claim was rejected only once in the continuing application. The applicant cannot file an appeal in a continuing application or after filing a request for continued examination, RCE, under 37 CFR 1.114 until the application is under a rejection. Accordingly, applicant cannot file a notice of appeal with an RCE regardless of whether the application has been twice rejected prior to the filing of the RCE. If the examiner's answer changes the order of references in the statement of rejection under 35 U.S.C. 103 and relies on the same teachings of those references to support the 35 U.S.C. 103 rejection, then the rejection does not constitute a new ground of rejection. A new grounds of rejection does not exist if the newly cited reference is added merely as evidence of the prior statement made by the examiner as to what is well known in the art which was challenged for the first time in the appeal brief. The citation of the reference in the examiner's answer would not ordinarily constitute a new ground of rejection within the meaning of 37 CFR 41.39 A2. You should now be more familiar with how to prepare for the proficiency exam, the basic components of the MPEP for future patent examining functions, and how to be efficient in looking up answers in the MPEP. This presentation covers examination guidelines relating to 35 U.S.C. 102 and 103. You will become more familiar with the requirements of these statutes, their exceptions, and the evidence effective to overcome rejections. Previously, we covered Parts 1 and 2 of MPEP 2100. This presentation covers sections 2150 through 2159 of the MPEP, including an overview of the AIA's changes to 35 U.S.C. 102 and 103, a detailed discussion of 35 U.S.C. 102A and B, the prior art exceptions under 35 U.S.C. 102B1, the use of affidavits or declarations under 37 CFR 1.130 to overcome prior art rejections, and determining whether an application is subject to the first inventor to file, or FITF, provisions of AIA. The changes to 35 U.S.C. 102 and 103 in the AIA do not apply to any application filed before March 16, 2013, even if a request for continued examination under 37 CFR 1.114 is filed on or after March 16, 2013. Applications filed on or after March 16, 2013 are also subject to pre-AIA 35 U.S.C. 102 if the application has never contained a claim with an effective filing date on or after March 16, 2013, and has never claimed the benefit of an application that ever contained such claim. This timeline shows 3 categories of applications and how to determine when AIA or FITF applies during examination. The red line in the middle of the timeline marks the March 16, 2013 effective date of the first inventor to file provisions of the AIA. As shown on the left side of the timeline, applications filed before March 16, 2013 must always be pre-AIA applications. As shown on the right side of the timeline, applications filed on or after March 16, 2013 with either no domestic benefit or foreign priority claims, or only domestic benefit or foreign priority claims to applications filed on or after March 16, 2013 must always be AIA applications. In the middle of the timeline, transition applications are applications filed on or after March 16, 2013 with at least one domestic benefit or foreign priority claim to an application filed before March 16, 2013. These are applications that straddle the line marked by the March 16, 2013 effective date of the FITF provisions. MPEP 2151 is only applicable to applications subject to examination under the FITF provisions of the AIA. After the AIA, 35 U.S.C. 102 continues to set forth the scope of the prior art that will preclude the grant of a patent on a claimed invention. In particular, AIA Section 102A1 identifies prior art by way of publication or other form of disclosure as of the public availability date, and Section 102A2 sets forth prior art based on the effectively filed date of a U.S. patent document. Admissions will still be treated as prior art under the AIA. A prior art disclosure cannot be disqualified or antedated by showing that the inventor invented the claimed invention prior to the effective filing date of the application. AIA defines the term effective filing date for a claimed invention in patent or application for patent as the earliest of the actual filing date of the patent or the application for the patent containing the claimed invention, or the filing date of the earliest application for which the patent or application is entitled to a right of priority, or 35 U.S.C. 119, foreign priority, 120, continuation, 121, divisional, 365, PCT, or 386, international design. A foreign priority date can be the effective filing date of a claimed invention under examination if the foreign application supports the claimed invention under 35 U.S.C. 112A and the applicant has perfected the right of priority. "35 U.S.C. 102 A.1 relates to prior art based on that material's public availability. Types of public availability include 1. A patent, 2. A printed publication, 3. Public use, 4. On sale, or 5. Otherwise available to the public. Public availability is established by patenting, description in a printed publication, public use, availability for sale, or other availability to the public before the effective filing date of the claimed invention. A reference that qualifies as prior art under 102A1 but does not teach every aspect of the claimed invention still qualifies as prior art that may be usable in a 35 U.S.C. 103 obviousness rejection. Patented means that a prior patent of a claimed invention will preclude the grant of a subsequent patent on the claimed invention. The effective date of the patent for purposes of determining whether the patent qualifies as prior art under 35 U.S.C. 102A1 is the grant date of the patent. Described in a printed publication means described in such a way as to meet the requirement of 35 U.S.C. 112A as to how to make, but not how to use, to be considered prior art. In public use means public use would need to occur before the effective filing date of the claimed invention to constitute prior art under AIA 35 U.S.C. 102A1. There is no geographic limitation on where prior public use or public availability occurs. On sale only applies to a sale that makes the invention available to the public. It does not apply to secret sales or offers for sale, such as commercial activity among individuals having an obligation of confidentiality to the inventor. There is no geographic limitation on where the sale or offer for sale may occur. Otherwise available to the public is a catch-all provision which defines a new additional category of potential prior art. Even if a document or other disclosure is not a printed publication, it may still be prior art under this provision. For example, an oral presentation at a scientific meeting, a demonstration at a trade show, a lecture or speech, a statement made on a radio show, or online material such as a YouTube video. Under 35 U.S.C. 102A1, there is no requirement for the prior art relied on to be by others. However, Disclosures made 1 year or less, that is, during the grace period, before the effective filing date of the claimed invention by the inventor or a joint inventor, or another who obtained the subject matter directly or indirectly from the inventor or a joint inventor, may fall within an exception under 35 U.S.C. 102(b)(1) to 102(a)(1). The grace period permits inventors to disclose their own invention without disqualification from patenting in the U.S. as long as they apply for the patent within 1 year of that disclosure. There are 2 exceptions to 102(a)(1) prior art. These exceptions apply only to certain disclosures made during the grace period. 102(b)(1)(a) accepts inventor-originated disclosures made during the grace period. An inventor-originated disclosure is a disclosure, such as a publication made by the inventor or joint inventor, or a disclosure made by another who obtained the subject matter disclosed directly or indirectly from the inventor or a joint inventor. A declaration by applicant under 37 CFR 1.130A invokes the 102(b)(1)(a) exception. It's called an attribution declaration. An attribution declaration is not required if it is apparent that the reference relied upon was really a grace period inventor disclosure. For example, if a patent document naming A and B as the inventive entity is relied upon in a rejection based upon its publication or issue date, and the application being examined names A, B, and C as the inventive entity, and the publication or issue date is 1 year or less before the effective filing date of the claimed invention under examination, then the patent document should not be applied in a prior art rejection under 35 U.S.C. 102(a)(1) because it is apparent that the patent document disclosure is a grace period disclosure. 102(b)(1)(b) accepts subject matter in a third-party disclosure made during the grace period if that same subject matter was contained in a prior inventor-originated disclosure. In this way, the prior inventor-originated disclosure may shield the claimed invention from a third-party disclosure made during the grace period. The third-party disclosure during the grace period is referred to as an intervening disclosure because it occurs before the effective filing date of the claimed invention and after the inventor-originated disclosure the applicant relies upon for the 102(b)(1)(b) exception. There is no requirement that the mode of the prior inventor-originated disclosure be the same as the mode of disclosure of the intervening grace period disclosure. There is no requirement that the prior inventor-originated disclosure be a verbatim disclosure. Any subject matter in the intervening grace period disclosure that is not in the prior inventor-originated disclosure is available as prior art under 35 U.S.C. 102(a)(1). For example, if the inventor or a joint inventor had publicly disclosed elements A, B, and C, and a subsequent intervening grace period disclosure discloses elements A, B, C, and D, the disclosure of element D is available as prior art under 35 U.S.C. 102(a)(1). If subject matter of an intervening grace period disclosure is simply a more general description of the subject matter in the inventor or inventor-originated prior public disclosure, the 102(b)(1)(b) exception applies. For example, if the inventor or a joint inventor had publicly disclosed a species and a subsequent intervening grace period disclosure discloses a genus, that is, provides a more generic disclosure of the species, the intervening grace period disclosure of the genus is not available as prior art under 35 U.S.C. 102(a)(1). Conversely, if the inventor or a joint inventor had publicly disclosed a genus and a subsequent intervening grace period disclosure discloses a species, the intervening grace period disclosure of the species would be available as prior art under 35 U.S.C. 102(a)(1). An affidavit or declaration under 37 CFR 1.130b is used to invoke the 102(b)(1)(b) exception. To disqualify a disclosure as prior art, the applicant must establish that the subject matter disclosed had previously been publicly disclosed by the inventor or a joint inventor or another who obtained the subject matter disclosed directly or indirectly from the inventor or a joint inventor. Applicant's declaration under 37 CFR 1.130b is called a prior public disclosure declaration. (35 U.S.C. 102(a)(2) allows use of U.S. patent documents as prior art based on a filing date. The only documents usable under 35 U.S.C. 102(a)(2) are U.S. patents, U.S. PG-Pubs, and WIPO publications of international applications that designate the U.S. To apply the U.S. patent document, for example, U.S. patents, PG-Pubs, and WIPO publications of international applications that designate the U.S., as prior art, the U.S. patent document must 1. Name another inventor, 2. Be effectively filed before the effective filing date of the claimed invention, and 3. Describe the claimed invention. In view of the inventor-originated disclosure exception under 35 U.S.C. 102(b)(2)(a), which will be discussed a little later, in order to be applied as 102(a)(2) prior art, the U.S. patent document must name an inventor not also named in the examined application. The U.S. patent, U.S. patent application publication, or WIPO published application must have an effectively filed date before the effective filing date of the claimed invention in question. Note that it is possible for a U.S. patent document to qualify as prior art under 35 U.S.C. 102(a)(1) by virtue of its publication or issue date, as well as under 102(a)(2) by virtue of its effectively filed date. A U.S. patent document may be usable under 35 U.S.C. 102(a)(2) with its domestic benefit date or its foreign priority date. 35 U.S.C. 102(d) specifies the requirements for this use. 35 U.S.C. 102(d) requires that a prior filed application to which a priority or benefit claim is made must describe the subject matter from the U.S. patent document relied upon in a rejection. However, the prior filed application does not have to meet the enablement requirement of 35 U.S.C. 112(a). Foreign priority dates of U.S. patent documents are available to examiners as 102(a)(2 prior art dates. There does not need to be a WIPO publication in English for the U.S. patent document to be applied under 102(a)(2 with its international filing date. However, if a WIPO publication itself is used as prior art under 102A2, it must designate the U.S. PCT applications designate the U.S. by default, but always check to make sure this is the case. 102B2 provides 3 exceptions that can disqualify 102A2 prior art. 102B2A and 102B2B are 2 of the 3 exceptions. 102B2A applies to inventor-originated disclosures. 102B2B applies to situations where the inventor or inventors disclosed the relevant material before the effectively filed date of the U.S. patent document that is the potential prior art reference. The 102B2A exception disqualifies a reference as prior art under 102A2 as of the effectively filed date if the subject matter disclosed was obtained from one or more members of the inventive entity, either directly or indirectly. Typically, the 102B2A exception is invoked in response to a prior art rejection when applicant files an attribution declaration under 37 CFR 1.130A, showing that the subject matter disclosed was obtained directly or indirectly from the inventor or a joint inventor. That is, an inventor-originated disclosure. In other words, the attribution declaration attempts to show that the reference disclosure is the inventor's own work. If the patent document under consideration does not name any inventor in addition to the people named as inventors in the examined application, then it is clear the people named as inventors in the patent document did not obtain the relevant subject matter from someone outside the inventive entity of the examined application. In such a situation, the examiner can tell the 102B2A exception applies, and a 130A declaration would not be required to establish that the 102B2A exception does apply. The 102B2B exception disqualifies the effectively filed date of a U.S. patent document reference that occurs after the inventor-originated disclosure and before the effective filing date of the application being examined. In effect, the material in the inventor's disclosure masks out that same material from the subsequently filed U.S. patent document reference. Applicants use prior public disclosure declaration under 37 CFR 1.130B to invoke the 102B2B exception. This is typically done in response to a prior art rejection. When it comes to overcoming 102A2 rejections with a 102B2B declaration, 37 CFR 1.130C does not prohibit applicant from relying on a prior inventor-originated disclosure outside the grace period, even though 37 CFR 1.130C prohibits an applicant from overcoming a 102A1 rejection by way of a prior inventor-originated disclosure which occurred outside the grace period, as discussed previously. However, if applicant tries to overcome a 102A2 effectively filed prior art date by way of a prior inventor-originated disclosure, which occurred outside the grace period, the prior inventor-originated disclosure cited by applicant will be the basis for a 102A1 rejection, which cannot be overcome by any 1.130 declaration. Remember that there are no grace period considerations with respect to 102B2 exceptions to 102A2 references. Specific material in the inventor's prior disclosure masks more general material in the subsequently filed reference, but generic material in the inventor's prior disclosure does not mask more specific material in the subsequently filed reference. The third exception to 102A2 prior art is the 102B2C exception. It excludes references under 35 U.S.C. 102A2 if, not later than the effective filing date of the claimed invention, the subject matter disclosed and the claimed invention were owned by the same person or subject to an obligation or assignment to the same person. Remember that the 102B2C common ownership exception does not apply to 102A1 prior art, which is based on a public disclosure. It only applies when a U.S. patent document is used based on a filing date. Again, there are no grace period considerations when applying 102A2 references. For the 102B2C exception to apply, the subject matter of the potential 102A2 reference and the claimed invention in the application under examination must have been owned by the same person, subject to an obligation of assignment to the same person, or deemed to have been owned by or subject to an obligation of assignment to the same person, not later than the effective filing date of the claimed invention. If this exception applies, a U.S. patent document cannot be used as 102A2 prior art as of its effectively filed date, but it may still be used as 102A1 prior art as of its publication date or patent issue date, since there is no common ownership exception for 102A1 art. 35 U.S.C. 102C spells out the conditions under which a joint research agreement is considered common ownership with respect to the 102B2C exception. These conditions require that the subject matter disclosed in a potential prior art U.S. patent document was developed and the claimed invention was made by or on behalf of parties to a joint research agreement that was in effect not later than the effective filing date of the claimed invention. The claimed invention was made as a result of activities within the scope of the joint research agreement, and the application that includes the claimed invention must name or be amended to name the parties to the joint research agreement. Applicant can invoke the 102B2C exception in response to a rejection relying on 102A2 prior art. Make sure that the applicant's statements meet the requirements of the exception, especially with respect to the existence of the common ownership or obligation of assignment not later than the effective filing date of the claimed invention. If a request to correct inventorship stands dismissed by a PTO deciding official, a 35 U.S.C. 101 or 115 rejection could be made on the basis that applicant has acknowledged a still unresolved improper inventorship. The applicant or patent owner may file an affidavit or declaration, but the affidavit or declaration itself should be signed by a party with first-hand knowledge of the relevant fact. In most instances, that means the inventor or inventors. An affidavit or declaration under 37 CFR 1.130 cannot be used to overcome a rejection based on a 102A1 reference with a prior art date outside the grace period. Nor can an affidavit or declaration under 37 CFR 1.130 be used to overcome a rejection based upon a U.S. patent document that claims the subject matter relevant to the rejection and the applicant files an attribution type declaration. Since this situation may require a derivation proceeding because the affidavit or declaration implies that an inventor named in the U.S. patent document reference derived the claimed invention from the inventor or a joint inventor named in the application, or patent being examined and the office cannot issue two patents containing patentably indistinct claims to two different parties. An affidavit or declaration under 37 CFR 1.130 cannot be used to overcome a rejection based on a 102A1 reference-based inventor-originated disclosure that occurred outside the grace period, nor can one be reasonably relied upon in a prior public disclosure declaration to overcome 102A2 prior art because the prior inventor-originated disclosure would give rise to a 102A1 rejection that could not be overcome by another declaration. You should now be more familiar with how to prepare for the proficiency exam and how to handle rejections under 35 U.S.C. 102 and 103, as well as the use of affidavits or declarations to overcome prior art rejections.